Crime Talk aficionados, thanks for sticking around and joining us. As we just heard, Judge Boyce will be collecting his thoughts before he gives his findings of facts and conclusions of law regarding the hearing, as well as the closing arguments that we heard from John Pryor, which is obviously Chad Daybell's attorney, Mark Means, Lori Vallow's attorney, and then Mr. Troy Evans, who has stepped in to help defend, I guess we can say, not really defend, but argue against the motion as it relates to the motion to disqualify. Now, I have said this before. When you start making allegations and accusing not only just another attorney of unethical conduct, but of accusing a prosecutor of unethical conduct, you better have your ducks in a row and you better be absolutely certain of that. And my opinion, and we'll see if I was correct or if I'm completely wrong in this particular case when Judge Boyce issues his ruling. I've read the transcript. I listened to the tape. There's nothing, in my opinion, that amounts to witness tampering, making a witness suggest anything, to use their words, coercion, manipulation, coaching, and influencing were words that Attorney Means used repeatedly to describe the interaction of these contacts between Miss Shiflett, who is Lori Vallow's sister, who contacted the police so that she could tell the police what she knew. She brought her attorney to the conversation. The attorney, Garrett Smith, recorded the conversation, didn't tell anybody that he was recording the conversation, at least in this particular scenario, but he didn't object to anything going on at that time. I'm really not sure what was inappropriate here. Was it an introduction? Yes. Did he say a lie? I want you to say this. Hey, do you know anything about this particular subject? Hint, hint, wink, wink, nudge, nudge. No, there was nothing there. This is a niece, or I'm sorry, the aunt of these children that are now deceased and are subject to the charges, JJ and Ty Lee. And in this particular situation, he's being, for lack of a better term, hey, I'm the prosecutor in the case. I understand that your sister is in a tough spot, but he basically says she's going to have to pay the consequences for what we believe that she did. We also think that maybe she's being manipulated. It'd be great if she talked to us, but she's not. He can't do that. He didn't say, go tell her to cut a deal. There's nothing there. So in my humble opinion, and like I said, we'll find out here in about an hour whether I am correct or whether Attorney Pryor and Means are correct and that Mr. Woods should be completely disqualified from this case. Bottom line is, I just don't see it. Let's see, as it went through this arguments by Mr. Troy Evans on behalf of the government, the motion to disqualify, they're basically saying it's going to result in an unfair trial. I really don't see how that's going to result in an unfair trial. These witnesses, this witness is going to be there. She interviewed for hours with other police officers in that hearing. What is appropriate is a thorough and extensive cross-examination of this particular witness if the defense thinks that she is somehow not being truthful and providing a complete recollection of what she knows or doesn't know. It's not to disqualify the prosecutor in any way. Violation of the rules of professional conduct. Attorneys are bound by the rules of professional conduct. They're rules that guide us. Some are much more straightforward. Others have a little more leeway. I simply do not see anything that Mr. Wood did that was inappropriate. And frankly, as a defense attorney, if I thought it was inappropriate, I would say so. I would be all over that. Just because you don't like what the DA is doing, i.e. prosecuting your client, doesn't mean that he's doing anything unethical. And when you start throwing the big E word around against another attorney, I'm telling you, you better be right. Because if not, if you are accusing attorneys of unethical conduct and it's found not to be, guess what? You are the one that could actually be grieved. It's just, I just do not see it. This was somehow witness tampering, and Mr. Means tried to say, well, there was language in there that says, I would like, this is what I want. Yeah, I want to get this. I want to get this evidence. But he knows that she's not the witness to do it. Mr. Woods indicates on that transcript that he has heard the telephone calls between Lori Vallow and people, not their attorney, that he thought that she was going to maybe want to talk, maybe cut a deal, maybe explain to the prosecution where the children were at that time, what happened to them. And then somehow he says, looks like, Chad Daybell stepped in and sort of tried to influence that. He said he's not a good guy. Guess what? I'm sure if you sat in on interviews with district attorneys and victim advocates that go and talk about the family, say these are the charges. The defendant is done this, and this. We think he's a bad guy. We think he needs to go down on this. Is that unethical conduct? No. It's probably even telling the family what they already think if they're the victim of that particular defendant. The prosecution, I think, correctly rebutted a couple of these issues very well. There was no there was no witness tampering. Easy for me to say. Next, that the prosecutors now become a witness. No, if the prosecutor had become a witness, that would be a circumstance where, let's say, he one-on-one has a conversation with a witness. He maybe memorializes the statement. He's the only one there. Most prosecutors are smart enough not to do that. And then the witness says, that's not what I said. Well, at that point, yes, the prosecutor could become the witness. But guess what? Here we have the attorney who was present. We have no indication whatsoever that Ms. Shiflett is somehow recanting her statement. We have Garrett Smith, the attorney, who's also present, who recorded this. It's more than likely he could come, authenticate it, and if there's issues regarding what was said, that would be the case. But here we're not talking necessarily about a material witness. If Ms. Shiflett had said that Lori Vallow confessed to me and there were only two people present, and then she denied it, i.e. the two people were only Ms. Shiflett and Mr. Wood, then there would be an issue for that. But I simply don't see it because the prosecutor is not a witness in this particular case. The argument that the defendants may somehow file a civil action against the county because somehow Mr. Wood, I'm assuming, violated somebody's civil rights. I'm not really sure how they're going to make that claim. I think that's ridiculous. The Brady and Rule 16. Bottom line is, yes, the government has a duty to turn over what they refer to as Brady material. Brady material is anything that would reduce the culpability of a defendant. Well, guess what? Is there anything in that statement that somehow says Lori Vallow is innocent? There's nothing in there. It's an introductory comment. Like I said, maybe I'm wrong. Maybe this judge will have a much stricter standard throughout this and perhaps disagree with my conclusion. I think if most people are shocked and outraged, some of these, the expert witnesses, we had the was it Dr. Newton, Dr. Davidson. He was the the psychologist who's saying, oh, this use of these terms was there to simply influence the witness and get them to do this and suggestibility, blah, blah, blah. Okay. So the defense doesn't like what Ms. Shiflett's going to say. Cross-examine her on that. That's it. That's how I would handle the situation if I were the judge. Then we had Dr. Newton, who's the guy that teaches the class on professional responsibility. And forgive me if I'm wrong, but I think he's a law professor. Nothing wrong with law professors, but there's a lot of things they teach you in law school that don't have a whole lot of applicability as it relates to actually practicing law. In a perfect world, what is a prosecutor supposed to come and say, hi, I'm the prosecutor on the case. I can't talk to you about anything but tell the truth. That's it. No, prosecutors are constantly communicating with victims of a case, particularly in a case involving any kind of death. They become very close. I've seen prosecutors get invited, to weddings because they've spent so much time with the family. They're there to console them. They're going through a loss. They're not robots. Okay, there's nothing in that particular interaction. Like I said, in my opinion, we'll see if the court disagrees. I don't think they're going to, but if I'm wrong, I guess everyone will let me know. Hey, Scott, you got it wrong for sure. The language that was used in this closing argument by Mr. Pryor and Mr. Means, oh my gosh, basically saying that Mr. Wood got caught. He's lying, cheating, coaching, and intimidating a witness before a trial. Bold words, no doubt. And I don't think that is supported by it. And if Miss Shiflett thought that she was being bullied, intimidated, coerced, pressured in any way, don't you think the first witness the defense would have called to support their motion would have been Miss Shiflett? And she would have said, he talked to me. Wow, he put this mesmerizing spell on me, and I had this recollection of things that didn't happen, and I wasn't truthful. And it was all because of this conversation. Don't you think they would have done that? Hell, they had the attorney for Miss Shiflett, Mr. Garrett Smith. He's not running up and down saying my client was intimidated. He said the conduct he thought was unprofessional. Guess what, ladies and gentlemen? People talk about attorneys. The defense bar knows who the lazy prosecutors are. The prosecutors talk about who the defense attorneys are that haven't tried a case in years. Okay? They know the guy that will go to trial, the attorney that will go to trial, whether it's prosecutor or defense, and those that will not. And there's nothing in there that is not inaccurate. He says he states an opinion. The guy's not competent. When he's not running around calling me a liar, okay, which is all true. Mr. Means previously had said that the prosecutors were out there trying to do terrible, evil things, listening to their phone calls. Bottom line, I just think this is over-the-top conduct by the defense. I think the defense needs to be very worried. The case will go on, and I would expect that at the end of it, there would be a grievance based upon what was been alleged. You don't go around accusing prosecutors of committing crimes unless you're absolutely certain and you get it right. And we will have to wait and see what the judge ultimately rules. But I simply don't see it. And in this particular case, I thought Mr. Evans laid out rather clearly. Now, the burden is on the defense. The burden is on the defense because they're the ones bringing this particular motion. Just like when a prosecutor brings a charge or allegation, it is their burden to prove it beyond a reasonable doubt. Here, the burden is on the defense attorneys to convince the judge that there was such misconduct that his client's right to a fair trial had been somehow tainted in some particular way, and that the rules of professional conduct were completely ignored, and that involved witness tampering. And the only way that we can go forward is if the prosecutor is a witness in this civil case, or in this case. And oh, by the way, Judge, we may sue everybody. For what kind of cause of action? I'm simply puzzled as to what they would try to bring a civil case on. Disclosure of information regarding Brady and Rule 16, which are the rules of discovery. Mr. Means tried to bring up that he's, somehow wanted all this other documents turned over and supported. But the reality of it is, the judge interrupted him and said, "Hey, have you filed a motion to compel yet?" "Well, I'm going to, Judge." Well, you haven't yet. And maybe there's a reason why he hasn't produced any documents, because you've attempted to disqualify him. That kind of puts everything kind of on hold here. And I don't know. I'm telling you, if I thought that a prosecutor had done something questionable, if I thought that if I was the attorney in the case, if I thought a detective had done something questionable or unethical, guess what? Unless you're going to get a motion to suppress granted because of what a detective did, you save it for cross-examination. You save it at trial. I have many times when I've had witnesses that refuse to talk to my investigator and myself, I say, we've never talked. And in fact, I've tried to talk to you on several occasions. You refuse to do so. You remember that, witness? Yes. Well, since you wouldn't talk to them, let's talk about how much time you've spent with the prosecutor in this particular case. And usually there's an objection. The judge will say, "No, fair game. What'd you do to prepare for your testimony here today? How many meetings have you had? How long of those meetings have you had?" And sometimes they maybe give you a phone call. "Oh, and it wasn't documented." Oh, you're going to make more of hay out of that as a defense counsel in front of a jury at court if you can show that you think the prosecutor was somehow doing something shady. But from here, I'm of the opinion, I don't think Mr. Wood did anything inappropriate. But guess what? If I was the prosecutor, and assuming Mr. Wood wins, I would be like, war. War has been declared, if it hasn't officially been declared already. When you have two attorneys that are accusing you of criminal conduct, being unethical, I'm telling you, I would go to war with those individuals, and it would be done professionally, but no professional courtesies, no favors whatsoever. I would crush them, and I would let their clients know that, bottom line is, hey, I'm going to do everything I can. If your clients would like to have an offer, you come talk to me. But from here on out, it's nothing but GORT, and that stands for guilty or trial. Bottom line, okay? You plead guilty to everything, or we're going to trial. And I would do that. And the defense or the prosecution should say, "I'm going to give you everything you want, and guess what? And I'm still going to convict your clients." One of the arguments that the defense counsel brought up was that the prosecutor somehow went down to these interviews down in Arizona at government expense. Well, of course it is. He's doing his job. Of course it's state expense. Because she reached out. It is not uncommon for a prosecutor to be involved in a case to judge the credibility of witnesses. Is what this witness telling me? The prosecutor probably has a greater understanding of the nuances of the case than the detective, particularly one in Arizona. I'm assuming the one that they talked to was from Idaho, but the prosecutor can be in the room. I've sat through many an interview, and it's not uncommon, particularly in bigger cases, where the prosecutor is there throughout. in most federal investigations, if police are interviewing somebody and they have an attorney, the attorney's there, the prosecutor's there, and if somebody's smart, they say, you better get somebody here with some authority to actually cut a deal if that's what they're looking to do. Somehow the defense was shocked and outraged when warrants that were basically being issued by Idaho through Hawaii to search the residence of Chad and Lori when they're in Hawaii and they're there to search, but the police are there. Not uncommon. Do you think it's uncommon if there's a homicide case and the on-duty prosecutor gets a phone call and says, hey, this is a big one, you better come on down? And they get out of bed in the middle of the night and they go down to the crime scene and they're there to gauge the scene to get it. I can tell you, just yesterday, I was out walking with my investigator at a crime scene. That's what you do. You go to the scene to get a feel for it, to see what's going on. And you're going to be there to supervise the nuances of the case. As it was characterized by Mr. Pryor, this is one of the biggest cases, if not the biggest case in the state of Idaho. You think the prosecutors want to make sure they do it right? That's right, they do. Do you think that they're there to supervise? Absolutely. If there's a legal issue that comes up, what's the best way to do it when you got a 4-hour time change between Hawaii and Idaho? You have the prosecutor there. I just don't understand where the outrage is coming from. And I'm a defense attorney. I like to root for the defense. I like to root for the underdog, the guy that is charged. But I said it early on. I just don't think this motion had merit. We'll see. We'll see if I'm wrong in when the judge gives his ruling. I think the judge will say, there's no dispute as to the conversation, that a conversation took place, but there's nothing to indicate here. And I think the court will ultimately say that the defense has not met their burden to show that Mr. Wood somehow did anything wrong, criminal, unethical, or has made himself a witness in these particular proceedings. Now, this Judge Boyce seems very smart. And although I'm a firm advocate that cameras should be in courtrooms, in situations like this, I think it makes people more talkative, more verbose when they talk, because they are perhaps doing it for an audience that they think is out there. I think most of these closing arguments could have been wrapped up in about 10 minutes or less. The prosecutor, I thought, was frankly much more succinct in his argument. He laid out in his brief, they keep saying that we haven't presented any evidence, but what other evidence is there? You got the affidavit of Mr. Wood saying I've done nothing wrong. You have the recording that's been admitted into evidence. You've had two experts testify specifically regarding, one saying, we think it was coercive, the language. If you look at the language, they talked about the re-interrogation techniques, which is basically the investigative technique that's been used and kind of gone in disfavor over the years because, when there was usually a confession or something along those lines where somebody did something, they confessed to it, and then it turned out they didn't actually do it, usually the re-interrogation techniques. There's nothing to indicate that Mr. Wood was using the re-interrogation technique whatsoever. The re-interrogation technique is to go in and talk to somebody, explain, hey, you're a really good guy. Sometimes things happen, we're accusing you of A, but you know what? You may not really have done A. What you really may have done is B here. And you're a good guy. Maybe we can get you some help if you need it. And next thing you know, so the guy basically is confessing, well, yeah, I did do B. Oh, really? Well, if you did B, you probably did A, and thanks for confessing. So it's just kind of a way of befriending somebody to get them to say something that isn't true. Or to get it out of a witness, but there's nothing that would indicate that that's what was actually going on. But I digress. So this Judge Boyce, he seems very smart. I looked him up. It looks like he was in private practice. He was a magistrate before he was a district court judge here. And I think he's trying to give everybody the opportunity to have, lack of a better term, their day in court, make the record. But I thought that at points, maybe I never met the man, so I can't say, but it looked like he was getting a little frustrated by the repeated conduct. One of the things you do as a lawyer is if you have briefed everything, you've written it out, and you filed it with the court, as a general rule, you don't go back over it line by line if the court has it there. Provide something new. Provide some argument regarding maybe a little nuance that you'd like to highlight. But don't just regurgitate what you just said in your filings. So we'll go. That's just kind of a practice tip. I think that most judges are like, if I've read it, I have it. Don't just tell me again what you just filed. Oftentimes in those situations, when you file the briefs, you simply say, Judge, I've submitted it. I know you've read it because you're a thorough and prepared judge. Do you have any questions? If not, I think I would just like to leave this particular point. Sometimes less is more. But to go back through and start, most judges I know do not like it and get very offended when other attorneys start throwing the E word around. It's just not something you do professionally. It's just not something you do. And if it does happen, then you take the appropriate action. I've had to report one attorney to attorney regulation, and that was years and years ago, but I had a client. She cooperated in a case, and there was two attorneys on that case. One was kind of, he was getting a little older, and the other guy, I knew him. I knew him well. And it turned out that the older attorney sent an investigator to talk to my client because she was still talking to somebody in that little clique, and she agreed to basically, change a statement. And it all came out. And of course, the prosecutor went to me like, why are you letting your witness talk to my, I'm like, what the hell are you talking about? And it turned out that this other attorney had talked to my client without my permission. You don't do that. You just don't do that. It's unethical. And I had to file a grievance. And I remember, regrettably, I have to file this against another attorney, blah, blah, blah. But the other attorney who kind of brought in to help for the trial that wasn't aware of it, but he had to be grieved as well, said, Scott, you did exactly what you're supposed to do. But you don't throw those words around. You don't go into court. And I never said, oh my God, Judge, this and that. But the judge said, well, I'm sure you'll file something with the appropriate people that you had to do that. And like I said, you just simply do not sling those words around. Are there people that I think that are unethical attorneys? You betcha I do. But unless I have some direct evidence, am I going to do? No, you don't do it. Do I think that there are prosecutors that played hardball? If Means and Pryor are offended by this conversation, I could show you some, tactics that prosecutors have really taken that even then is not rising to the level where they're going to get disqualified. I once had a case where a prosecutor was prosecuting my client, and maybe hypothetically before I got in the case, maybe he charged at an aggressive manner at the district attorney, and he was charged with threatening a prosecutor. And we got appointed, and so she was obviously a victim in one case and a prosecutor in the other. And I'm like, hey, you can't do that. It's gonna affect your ability to be fair on this case. There may be a deal. You got to get off. And the district court judge said, you can't be both in the same office. Just put a special prosecutor on. Why are we doing this? It got appealed, and unfortunately, never got resolved because the client passed away. So, I mean, there are, like I said, if this is what the attorneys in Idaho, and maybe that's a good thing for Idaho, but if they think that that is somehow criminal conduct, intimidation, all the things that they're alleging and throwing some serious rocks and arrows at Mr. Wood, they haven't dealt with some of the prosecutors I've dealt with over the years, but I bet you if Mr. Wood does not get removed from this case, stand by. He is, I would not talk to either one of these attorneys in anything other than written communication, so that there's no way that they're going to accuse Mr. Wood of anything as far as misconduct. And the argument that somehow they're going to have a hearing based upon every introductory interaction that the prosecutor or police department, I mean, why stop with Mr. Wood? What about the police? When they talk to people and they, hey, how you doing? Come on down, blah, blah, blah. Hey, we're going to talk with you. All that stuff. And my guess is if these police officers were really good, these detectives that did the interview of Ms. Shiflett, they're going to say, all right, you understand we're recording this conversation here today. You're doing this freely, voluntarily. Yes, I am. Yes, I am. Has anyone threatened you, made any promises to you, done anything in any way to get you to basically change your testimony or not tell me the truth here today? I would bet that was the introductory comments made by the detectives. And where's the taint? Like I said, where is any misconduct? Like I said, anything's possible, and sometimes the courts shock and surprise you. But in this particular situation, I would be shocked if Mr. Wood was kicked off the case. Peggy, Scott, what happened to your forehead? Good question. I think that comes from stress. I was in a court hearing this morning, and let's just say things, witnesses turned from what they had previously said, and let's just say there was a little tension in the room, and I don't know why, but apparently when I get probably if these blood vessels pop, maybe I'm not having an aneurysm or something, I guess. But yeah, I didn't have them when I left the house this morning, that's for sure. And it was only one hearing today that got a little contentious. So that's probably why, like I said, got a couple of blood vessels there because my head was about ready to explode, apparently. So yeah, that's what that is. I was trying to hopefully, think that nobody saw anything, but let's face it, everybody does it. And we don't do our makeup here at Crime Talk. This is just the lovable face that you get here all the time, good, bad, and ugly. Just the way we kind of like to bring it to you, in on all of these cases, because, I mean, we talked about this the other day. I mean, just because you want something to be true doesn't make it true. Just because you've committed to one particular side doesn't mean that, the other side is always right and you're, or they're always wrong and you're always right. There are gray areas for sure, but, you have to look at it objectively. And I just would be very surprised. Somebody sent me something from, it was another channel. I think it was like a Court TV or whatever. And they're experts, basically were, oh my God, this is the worst thing ever. This is just terrible, terrible, terrible. And like I said, if I had that transcript and I thought that there was something inappropriate, I'd want to bring it up at trial. Now there's going to be so much stuff going on to try and limit anything that goes on. And let's face it, why do they want Wood off the case so bad? You have to really wonder why. Is it because they think they did something unethical? Okay, apparently the defense, that's the grounds they're staking out. But prosecutors tend to stick together. And even if, let's say Mr. Woods did get excluded, you think it's going to somehow change the complexion of the case? Probably doubt it. Normally when a prosecutor gets disqualified, they have like these agreements, like if we need a special prosecutor, we'll be yours. And if you need a special prosecutor, we'll be ours. And sometimes you have to consider, who am I going to get if I get this prosecutor kicked off, or I move to, change a venue or something along those lines. You have to be careful what you wish for sure when you do that. But somehow, and I know Mr. Pryor isn't thinking this, but I think they're trying to make the leap that if Mr. Woods was so bad, violated my client's due process right to a fair trial, Your Honor, the only remedy would be to dismiss these charges. They didn't say that, but that's kind of what they're leaning towards. No. As the prosecutor, Mr. Evans, outlined in this court, to the court in his arguments, is that there are things that even if a judge thinks a violation has been done, unless it's so egregious and outrageous, you're supposed to tailor a remedy that is the least severe possible in any particular way. Kind of a classic example of that is if there is a case and a witness says something that everybody knew that the witness shouldn't say, and it potentially could result in a mistrial. Say, for example, the police officer on the stand is like, well, and I was aware of his prior criminal history. Objection. When we approach judge and move for a mistrial, the judge probably isn't going to grant you a mistrial just because of those particular words. He may admonish the witness. He may instruct the jury that they cannot consider this in any way whatsoever. But they're probably not going to grant a mistrial because a mistrial is an extreme remedy. Just like removing a prosecutor is a very extreme remedy. I just don't see this judge taking that leap in any particular way. Let me see if I can read some of these questions. Okay, I agree. Carol there. Yes, why do you have to ask us, why do they want him off the case so much? Is it because he's an experienced prosecutor? Is it because they want to cut a deal, but he's not listening to it? Like I said, I don't get it. I think they've taken a completely wrong approach to this particular matter, and I think that it's not going to end well. Hopefully we'll find out here in just a little bit, because this case needs to progress. I'm a little surprised that the court needed another break to prepare the finding of facts and conclusions of law. Kind of like, hey, Judge, all the attorneys probably worked late last night outlining their stuff. Why couldn't you have done that? Was there something that was so unique that was presented that now you have to somehow clarify that? I don't know. Alicia, Scott, why do you think murder charges haven't been brought yet as it relates to Lori and Chad? Well, I've explained this before, because I think they have proof issues as to who actually killed the children. Alex Cox, the sister of Lori Vallow, is now deceased. I think a reasonable argument can be said that perhaps he's the one that did that. And unless you can prove and show that they were involved with and know that something bad was going to happen to the children, what evidence do you have? Obviously, Alex Cox is dead. Even if there's things on the phone, you have evidentiary issues that may not be able to, get over those hurdles. Just because you have a hunch or a suspicion doesn't mean that it is legal and competent evidence to overcome those evidentiary hurdles. And understand, it's supposed to be tough when you go to court. whether it's for the prosecutor or, if you have a civil case, it's supposed to be tough to prove a case because you just don't want people saying they did something wrong to me. Okay, what? When? Where did it happen? Do you have any witnesses? You have to be able to prove those things. I think that and I've said this before, Mr. Woods seems like a competent prosecutor. If he had enough evidence to charge it, I think he would. The police, obviously they were able to discover the bodies in this particular case of J.J. and Ty Lee. And if they thought that they had sufficient evidence that they could present to a judge a warrant for the arrest for murder, I'm sure they would do it. The bottom line is there's something missing in their evidentiary link for Lori Vallow and Chad Daybell. And like I said, it's supposed to be tough. Burden of proof is proof beyond a reasonable doubt. The standard to get a warrant is simply probable cause, a much lower standard. So I think that if they had it, they would do it. I don't think they have it unless and until one of the co-defendants in this particular case would decide to cut a deal and point fingers at another person. But not a whole lot of incentive on their part to do that, because then basically they would be in trouble, so to speak, and probably not get a deal. I mean, look at it. They're facing 10 years, 10 years on 2 counts of basically concealing evidence, right? You get charged with murder, you roll, but what's the incentive? Hey, worst case scenario, I'm looking at 10 years. Okay. Versus life or possibly even death. Not sure it would be necessarily a death penalty case, but the bottom line is, what's the incentive? Unless the incentive is a golden ticket to go home, I just don't see it. So, as I Am Human here states, the pings, the closed circuit TV, there's 26,000 pages of electrical data evidence to sift through. Yeah, but you know what? They've had 8 months by now to do that. Like I said, I think they would have done it by now. Hey, I've been wrong. I can be wrong. I'm going based upon what I know, and I will change my mind based upon, whether the law changes or whether the facts change. But based upon the facts that I know right now, that's why I think basically nothing is going to happen, so to speak. So that's where we remain on that. What time did the judge head out? Do you remember, Frank? We 15 minutes. Oh, about 15 minutes? Yeah. Okay. Yeah, 15 minutes. Salt of the earth. Scott, would you do what Smith did if your client didn't complain? I would, Garrett Smith was the attorney for Ms. Shiflett who turned over this recording. More than likely, I don't know, I don't recall off the top of my head whether he reached out to Means or if Means and Pryor reached out to him and said, I got this thing. They listened to it. It's inappropriate because Mr. Means, got his feelings hurt that he said he wasn't competent. And that's affecting, his ability. I mean, listen, no one's refuted the fact that Mr. Wood said that Mr. Means has never had a felony case before. Okay? Just because you're an attorney doesn't necessarily mean that you are competent in a particular area of law. You can get up to competency, but it doesn't necessarily mean that you are competent just because you're an attorney to handle every type of case that comes through the front door. We'll see. I mean, I think it's ironic that the defense was so concerned about pretrial publicity, his clients receiving a fair trial, and they're the ones that have attempted to perpetrate a further growing circus in this particular case. Like I said, we'll find out together. It's kind of like when I tell a client when we're waiting for a jury verdict and you tell him, all right, this is the second worst part. And he says, the client will ask, well, what's the worst part? When they say they have a verdict, okay, it's your stomach just sinks, you come down. It's like, we'll find out together what happens. We're going to find out at the same time what happens. I think if I was the judge, based upon what I've seen, and I've watched the closing arguments and watched just about every minute of the previous hearing, I think if I were the judge, I would find that the defense hasn't met their burden, that none of this rises to the level of what they would do. And I think I would admonish both of the attorneys for their choice of words going after Mr. Wood the way they did. You can say lots of things. You can say, Judge, I'm concerned. Concern is, Judge, I'm concerned the way things were conducted. You can say, I don't like the way things took place and went down without accusing somebody of criminal conduct. It's just going to be, I think it's going to be interesting. Like I said, I think Mr. Woods will remain. If he does remain, it'll be very interesting how things are conducted here on out. But think about it. If the prosecutor that's prosecuting your case, the one that can give some leniency, so to speak, if there were going to be a plea bargain in place, do you think after being wrung through the mud, called all kinds of disparaging things like you're a liar, you are unethical, you manipulate coerced witnesses, do you think you're going to do any favors above what you are professionally and legally obligated to do? I just think it's, like I said, we'll see what Judge Boyce says he's going to do here shortly. But the bottom line is we'll find out together. Generally overall, and I've said this before, I think Mr. Pryor obviously is a very experienced criminal defense attorney. As another defense attorney, you can tell that he is. He kind of gets to the point, maybe a little verbose, a little talk, over the top, but means, and maybe it's just me, he probably would say the same thing about me, but man, that Scott Reisch just bugs the hell out of me, every word that comes out of his mouth. But there's something about Mr. Means, and I'm telling you straight up, I'm not going to, every time he opens his mouth, I literally just want him to sit down. The less he says, the better. Even when he's sitting there scribbling, always looking down at his paper when he's doing, there's something about him that just rubs me the wrong way, and I don't know what it is, but I'm telling you that in complete candor. Just because, I don't know, it's just my personal, there's something about the way he conducts himself that he just bugs me. I don't know why. I am human. Pryor throws word salads everywhere. Yeah, he may not have been as focused as, say, perhaps Mr. Evans, but that's the defense attorney in him. Sometimes you got to deal with what you got, but I just simply, Marion's probably saying why everything's dehydrated. You're probably right. I have been drinking too many Red Bulls lately, not enough water. Then I get these lines where my head's going to explode. Can you go read this, Scott? I don't have control of that comments. Do I have to go back up? Yeah, go up a little bit higher. I can't remember where. Okay, go down a little bit, please, in the comments there. Sorry, I'm just trying to look at the comments. I don't have control of that here. The hardest working man in show business, Frank does. And let's see here. Question, Scott Woods. Okay, Scott Woods was recorded telling Summer her sister will be charged with conspiracy to commit murder. Was he lying to her since no charges have been filed to date? Wow. No, wasn't a lie. At that time, the way I read it was, we could or we're going to charge her with murder. Is that a secret? Is that something, it's not like he's talking directly to her. Does he know that that she's gonna talk to him? I don't know, maybe not, but hopefully they're not going to be talking about the case on the phone, because it would all be copied, I'm sure. But the bottom line is, he's saying, hey, we're going to charge him with conspiracy to murder. Now, this was back in October. I think that was the date of the interview. I don't have it in front of me, but it sounds about right. But the reality of it is that is, that's what he said he was going to do. Okay, he hasn't. Because an attorney, a prosecutor, has an ethical obligation that can only bring charges if they believe they can prove it beyond a reasonable doubt. And if he thought that he had that to do that, that's okay. But they can't do it until they has that ethical obligation to do so. But saying, hey, I'm going to, that's his goal. It's the prosecutor saying, hey, as a family member, I understand you're in a hard spot. You want to help your sister, but you also want to make sure that justice is there for Tylee and JJ. I understand that. Prosecutor saying, I can bring the most serious charges I can possibly come up with. Once again, that's my opinion. I don't think that was anything inappropriate whatsoever. We touched on it yesterday on our show, where we talked about the fact that the defense didn't want any more briefings, but yet it seems like at least Mr. Means submitted a brief. The prosecutor submitted a brief, kind of a summary of their closing argument, which is fine. Most judges usually like that, but the defense didn't want it to be required because it takes time, and time equals money. Attorneys like to be working on a particular case. They like to work throughout their day, most of the day, so that they can make money. And if they're not, working on a case that they can't get paid, I brought it up that when they start complaining about the cost of, going to court, writing briefs, showing up for court, it costs money. That usually means the funds are drying up. This case, given the amount of discovery that would be there, all the data from the phones and all the dumps and everything like that we heard about back at the preliminary hearing, that'd be a full-time job. And then you go and start create, little rabbit holes. This is why, and people don't understand it. An attorney says, hey, I'm not going to charge you a flat fee. I'm going to charge you an hourly fee. Because in a felony case, you do not know what rabbit holes that you may have to go down and investigate. And they have to be investigated and they have to be brought up. Well, why didn't you do this? But then when the attorney starts saying, hey, we got this issue here, you're in for a penny, you're in for a pound. What are you going to do? Work for free? Well, you're not going to do that more than likely until all the money's gone. And then they're going to have to decide, do they want to be working on the biggest case in Idaho ever for free? Or do they want to get paid for it? Do they think their, 20 minutes of fame will be enough to carry them for the next 20 years if they work for free? No, probably not. What was the attorney's? He represented. Why can't I think of his name? The attorney for Mark O'Mara. That was it. Mark O'Mara. He represented George Zimmerman. He got on that case. Zimmerman didn't have any money. He kind of stayed on. I've talked to Mark O'Mara at National Trial Lawyers. I think he's the president of National Trial Lawyers, or he was. Maybe he's moved on from that. But he and I are, he does criminal work. But when you talk to him about the George Zimmerman case, it was the kind of case where he got on and it's kind of in for a penny, in for a pound, and they had to basically set up a defense fund for that. And they won the case. It worked out well for O'Mara. I think he got a gig with CNN to be their legal contributor at some point. I don't know if he still does that. And he's done well for himself. I think now he does a lot of some mass tort stuff, but things are going well for Mark O'Mara, and I wish him very, very well. But when he was on that case, he was literally like, they're going to repossess the car. How are we going to make the bills? Because there was no money coming in because the case was a full-time case, and that's what this case is. And you think about it. Let's just say they're making $300 an hour, $400, $200. You round the numbers off wherever. Assuming they're working, let's say 8 hours a day. If they come in and they work on nothing but that, billing 8 hours a day. Some days it's going to be more, a little less. But figure, even at $300, that's $2,400 a day. How quickly does that go by? You do that a couple days in a row. That's $5,000. That's 10. It's like $1,250 a week. If you're working on it full time and reviewing all that discovery, that's how these cases can get so expensive so quickly. And when you have big cases like this, and God forbid you have more than one attorney working on it, so that you keep some perspective and say, you have to do that. We're fortunate enough here in our practice where we have 4 other attorneys here that work for me. And it's great because you can bounce things off. Hey, will you take a look at this? Will you read this motion? Am I going on a limb here? And there's been times where I got all fired up and somebody in my office will say, let's pump the brakes on that, Scott. Let's take a look at this. And I'm glad they did. And there's other times where it's like, is that an issue? And other people are like, oh, that's a huge issue. So it's just good to have that. But, these cases are expensive, and most people cannot simply afford to defend a criminal case oftentimes the way that they are intended or should be represented. I mean, it takes time to go to the jail, talk to the clients, go over things, explain things to them, how this fits into the bigger picture. It takes time. I mean, I was at the jail last night till 7:30, going over information, explaining things, make sure everybody understands it. These are reasons, these are tactical decisions that we're making. We're going to push it on, explaining things. That takes time, let alone going back and reviewing and figure out, all right, how does all this stuff fit into the case as a whole? How does this fit into the overall theory? What is the defense? What evidence do we have to come up with to fit this particular defense? Do they have enough to make their case under the elements? Is there some case law out there that I need to research that's interpreted the instructions a little differently? So it just really depends. And I'm telling you, it's expensive. I mean, people just do not appreciate that. But most serious felony cases, we take on an hourly fee basis just because you do not know what issues are going to pop up. Next thing you know, you spend 2 days on a hearing that you didn't think that was going to be anticipated. Okay, I'm being told by Frank that we are coming back on. We'll see what the court concludes, and then we will provide, I guess, our analysis, and we can see whether I have to eat some humble pie or I can say, I was right. I guess we'll wait and see. As I tell my clients when we wait for that jury verdict, we'll find out together. So looks like we're going to go back. So I guess we'll go. I guess I'll continue to talk until they actually come back on here as well. Good question. Tammy, could the judge come back for sanctions against the defense attorneys? The biggest sanction in this particular point would be to deny their motion. They just spent all this time on this motion, and if they lose it, that's going to be a big blow to them. They burned bridges with the prosecutor. They spent a bunch of their clients' money and got nothing out of it. That'll be a pretty big sanction. The judge is not going to be like a civil case where they're going to say, oh, this is frivolous, and we're going to impose costs against the defense. So not really. Now, the prosecutor, Mr. Evans, did state that the appropriate forum, if they think that something unethical has taken place, is with the bar. That's true. The court has no real ability to sanction what they refer to, even if it was unethical. Obviously, the big sanction here would be if they thought it rose to the level to remove Mr. Wood. That would be a huge sanction, and then there'd be an issue with the bar. But that's it. But normally, you don't grieve another attorney in the middle of a case, because that's when emotions are high, and it's just not done. I mean, it's sometimes called good lawyering. But these days, it just seems like everybody is everything has to be a gotcha. Everything has to be a gotcha, and I just don't get it. And everybody wants to get the other side in trouble and do this, and I just do not, I don't get it. Will Mr. Wood, if he's retained, or not retained, but not removed from this particular case, what will they probably do? I assure you he's going to have a witness there if he's having any introductory comments at all. And that's a shame, because, a good prosecutor would tell you, I don't have to turn over everything that we talk with about, the family. Hey, this is what we think we're going to do. This is what we're asking for. Is there something that you could live with, because the trial process is long, it's lengthy? Is there something that you would be willing to accept if we were to resolve the case? And we've talked about this before. These are the conversations that prosecutors have with family members. Okay, hey, this other attorney on the other side, he could be really good. Say, hey, I've dealt with him before. I think I've got enough evidence to prove the case, but if there's some guy that could possibly pull this case out, it could be that guy. Okay, you just never know. But that's what prosecutors do when they're talking to family members. Like I said, we will find out here, hopefully in just a few minutes, what the court decides. I think that, let's see, Janine Scott, thanks for this. The time when there's so much distrust of our legal system, you bring us the facts. Well, I try to. I mean, and we've talked about this before. I don't want to repeat myself, but, some people get so upset when I give analysis of a case where, for example, the Ahmed Arbery case. I've read the jury instructions, the law as it relates to that particular case, and I think all those people are in trouble, and they're probably going to go to prison. I don't think what they did was appropriate under the law, and their defenses that they were claiming are not there as well. And then people get mad at me, and then they say, well, how can you think that Kyle Rittenhouse kid has a defense up there? Well, because I've looked at, I'm not going to say it's all of it, but some videos that show that there were a lot of things going on that weren't known at first. And people get upset with me like, well, I don't know. I just don't understand it. But as an attorney, you have to look at this and analyze this. Okay, I want to help my client, but do do we have what it takes to prevail? You have to have those conversations saying, this is good for one side, this is good for the other side, whatever side you're on. But you have to do that analysis. And if you just ignore it and say, I'm right, guess what? Your client could be going to jail and you're not doing your job as an attorney. And, it's one of the things that they teach you in law school is to think like a lawyer, think like an attorney. It drives some people nuts, and sometimes you maybe overanalyze things. But the reality of it is, it's a good way to think. It's called, what proof do you have? Just because somebody says it's true doesn't necessarily make it that way. You have to have facts, evidence, eyewitnesses to something to do that. And not just, hunch, suspicion, speculation, bottom line. And, yes, are there things that we know in life with absolute certainty? Not necessarily. So you're not going to have, absolute proof, but you have to have proof. You have to have some evidence for that. And, the standard in criminal case is reasonable doubt. It's not a vague, imaginary, or speculative doubt, but a doubt that would cause people to pause in matters of great importance and say, am I convinced beyond a reasonable doubt? Not all doubt, not a shadow of a doubt, beyond a reasonable doubt. Would a reasonable person do that? People have doubts all the time that they overcome. Think about when you buy your first house. You think, man, I got this house. I'm spending all my money. And it keeps you up at night. Did I do this? Is this the right decision? You have doubts about it. But you work through it and say, yeah, it's a good investment. We're going to have a family. It's going to appreciate in value. It's really scary, but it's going to be okay. You've overcome that doubt. Reasonable doubt. Okay. So and I think that's the thing. Like I said, if you start thinking like a lawyer, sometimes it's a little frustrating to the loved ones around you. You can even come across as a little insensitive. But the reality of it is, it makes you think and say, okay, that's fine. Trust, but verify. But, you get very cynical in this job, particularly when you start getting burned a few many times, whether it be a client or anybody else. It's trust, but verify. I like you. You seem like a good guy, but the reality of it is, bring me proof. Client says, "Oh, I wasn't able to, I wasn't able to make a court today. I was in the hospital." Okay, that's great. That's great. All you need to do is, get me something from your doctor to say you were there. Not that I don't trust you, but no one else does. So those are the kinds of things that you have to do as an attorney. You have to be very skeptical sometimes, and it's frustrating. But the reality of it is that you get burned enough by people that you thought you can trust, and then you don't. And like I said, it's frustrating. But that's thinking like a lawyer. So let's see here. Let's see here. Man, you'd think they would come back up by now, don't you? We haven't lost anything, have we? Man. Yeah. Okay, so let's talk. Like I said, I think the judge will rule the way I think the analysis will go. But let's say it doesn't. What does that mean if there's a special prosecutor on the case? Well, they'd have to appoint a special prosecutor. That prosecutor would have to get up to speed, which would mean to go over all the pleadings, paperwork, all the discovery, everything in the case. And guess what? Mr. Wood would not be able to help them really do that. They're off the case, you can help with a smooth transition, but he can't consult. So yeah, it's which would take time, and it's not going to result in a continuance of the speedy trial in any way, because it's not the defense asking for it. The prosecutor would just have to get up to work. Hopefully, if that were to take place, Mr. Woods would have the Emma, are you coming back after, not the verdict, it's a ruling by the court as to whether there be disqualifications. But yes, we'll stay on and talk about the ruling. I don't understand what the judge, why it's taking so long. It's a little puzzling to me, other than he wants to make sure he gets it right. And I get that, to make sure he's dotted all his I's, crossed all his T's, so that it would stand up on any kind of appeal if there was one. But you would have thought that he would have written that out pretty much last night, and we'll see. I don't know. Surprised. But yeah, after the judge does give his opinion, then the plan is at least to talk briefly about the analysis of that, and we'll go from there. Probably won't put up our regularly scheduled show today, just because this has gone on so long. So we've interrupted our regularly scheduled programming to bring you this live special event. But I appreciate that everybody has stayed on even through the break. Hopefully I've provided a little more entertainment than looking at a blank screen that says the seal of the great state of Idaho as we wait for this. Hopefully provide some information regarding how this may come out. I'm trying to look at some of the comments here. Linda, did the defense attorney threaten to spend more unknown sums of dollars in retaliation of Wood's conduct? Weren't those attorneys complaining about how much money it was costing? I didn't take it as they were threatening to spend more money, just that it would take more money, because now they have to send investigators out to go talk to all of these particular witnesses. Well, I would hope that they were going to do that anyway. So I'm not exactly sure what that would entail. On a big felony case, when you have lots and lots of witnesses, this is the type of situation where you would have to hire an investigator. So when we talk about all those expenses for the attorney, and the attorney may go out with the investigator, maybe not for all of them, but the investigator has to review the discovery so he can ask intelligent questions. Some attorneys say, hey, I trust you, Mr. Investigator. Let's talk about the discovery. This is generally what I want to go over. Go talk to him. Some attorneys write out specifically every single question. Don't deviate, don't ask of that. But guess what? Private investigators don't work for free. If they have to travel, they'd like to get reimbursed for their airline tickets. They'd like to get reimbursed for their mileage, their meals, all that stuff. The client pays for it. So whatever amount of money that was paid to these attorneys, I can imagine it's going through real soon. All right, Judge Boyce has returned. We'll go back to the ruling. We'll see, did I nail it, or do I get to eat my words? We'll talk to you afterwards.
All right, Madam Clerk, are we ready?
Yes, Your Honor.
All right. Appreciate your patience. We're starting a little later than I indicated. We'll be back on the record. These are cases CR 22-2755 and CR 22-2838, State versus Chad Daybell and State versus Lori Vallow. The court took a recess after considering the closing arguments today, and I'm prepared to make a ruling on these motions. In this case, the defendants have each filed motions to disqualify the prosecuting attorney. The court has considered the pleadings, the evidence submitted in the hearing on January 6th, and the arguments that were submitted today. As a preliminary question, the court has to determine what is the appropriate standard of review for granting or denying these motions. Pardon me. As has been pointed out by both the experts and in argument, there really are no Idaho cases directly on point to identify what is the precise standard for this motion to disqualify a prosecutor pre-trial. And there's no Idaho precedent the court's aware of where this remedy has been ordered by a trial court in a pending case. Neither defendant provided any citation for an appropriate standard of review, but made argument in support of their belief of what the standard should be. The state has referred the court to a standard in the Weaver versus Millard case, which was set forth in the state's brief. That case is a civil case, and while it's instructive to the court, I do share a concern that was raised by Mr. Means in his rebuttal argument that the civil standard may not be appropriate for a criminal case, and that would be because of the heightened duties that a prosecutor is charged with and the additional constitutional protections that are afforded to criminal defendants versus a civil standard. And so in the court's opinion that the Weaver versus Millard may not be the correct standard and will not be used for determining these motions at this hearing. There is some Idaho case law out there that for good cause, a trial court can in its discretion appoint a substitute attorney for an indigent defendant, for example, and that would be State versus Lippert, 145 Idaho 586. However, that is for the constitutionally guaranteed right of representation of an indigent defendant and does not necessarily apply to a trial court having the ability to order a substitute attorney to represent the state. In looking at other jurisdictions then, the court has located a precedent out of New York that is persuasive and will be adopted in this case, as I think this is a novel issue in terms of precedent. The case I'm referring to is called State versus Paperno, a 1981 case out of New York found at 54 New York 2nd 294. And that case deals directly with the issue of a defendant's pretrial motion to disqualify a prosecutor. The standard as stated in that case is as follows. It indicates first, the burden is on, well, let me read that directly from the case. The standard they use is that on a pretrial motion to disqualify the prosecutor, it is incumbent upon the defendant to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. A mere assertion by the defendant that he intends to question some aspect of the prosecutor's conduct is insufficient. Rather, the defendant must demonstrate that there is a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So according to that, the burden is on the defendants to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. And second, there must be a showing that there's a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So in reviewing then the motions with that standard, I look at the motions which mirror each other in their allegations. The allegations are, number one, that the prosecutor alleged misconduct violated due process rights of the defendants under the Idaho and U.S. Constitution, right to a fair and impartial trial, that the prosecutor engaged in coercive, unduly influential, and intimidating tactics to manipulate a material witness in this case. The second allegation in the motions is the prosecutor in this case violated the Idaho rules of professional conduct, as well as the ABA rules by his actions. The third allegation is the prosecutor's alleged misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. Number four, the allegation that the prosecutor's alleged misconduct has made him a material witness in this criminal case. And number five, the prosecutor's alleged misconduct has caused the potential for future civil litigation directed at Fremont and Madison counties, as well as the prosecutor. And then number six, that the prosecutor's alleged misconduct has included concealing evidence in violation of Brady and Rule 16 of the Idaho Rules of Criminal Procedure. The court would note that in terms of the fourth allegation about the prosecutor being made a material witness in the case, there is some Idaho precedent on authority on when that occurs, and that would be the State versus Aguilar case. And that case is at 135 Idaho 894, and that states that the party seeking such testimony, meaning from a prosecutor, must demonstrate that the evidence is vital to his case and that his inability to present the same or similar facts from another source creates a compelling need for the testimony. Also, that a defendant has an obligation to exhaust other available sources of evidence before a court should sustain efforts to call a participating prosecutor as a witness, and that case states that such motions are generally disfavored. In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the three witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this hearing. So getting down to these allegations, counsel's alleged that there may have been or was a violation of Idaho Code 18-2604, which is Idaho's witness tampering criminal statute. Of course, to make a showing or to sustain the burden of violation of that would require the highest burden of proof because it's a criminal statute, so that would have to be shown beyond a reasonable doubt. Regarding the allegations of the Idaho Rules of Professional Conduct, of which there have been many allegations made, including Rules 3.3, 3.4, 3.7, 4.2, and 8.4 of the Rules of Professional Conduct, the court considers as a fact finder in this proceeding that the standard of review to determine if there's been any violation of the Idaho Rules of Professional Conduct would be clear and convincing evidence, and that would be found under Warner versus Stewart, 129 Idaho 588, and the matter of Daw, 128 Idaho 80. In regards to those alleged violations of the Rules of Professional Conduct, the Idaho State Bar governs the licensing of attorneys in the state and also enforces the Rules of Professional Conduct. There's an office of Bar Counsel that conducts those hearings, which are administrative hearings. The Bar Counsel has the responsibility of investigating, and I'll quote from a rule, all matters involving possible misconduct called to their attention, and that's Idaho Bar Commission Rule 504B2. The state, in its brief, pardon me, I think I misplaced that, cites to the case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could, of course, choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, as if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiflett in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing, and that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiflett. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions. Mr. Evans, I would ask that you prepare an order indicating that the motions are denied, and also include in the order the indication that the court would require a pretrial hearing to have an in-camera interview of Ms. Shiflett before trial, or, well, don't necessarily say it would be an in-camera interview, just say that a pretrial hearing would be required if she is in fact to testify at trial.
Very good, Your Honor. Thank you.
All right. Mr. Pryor, do you have any questions on the court's ruling?
No, Judge.
Thank you. Mr. Means, any questions on my ruling today?
No, Your Honor. Thank you for your efforts.
Thank you. And Mr. Evans, does the state have any questions on my ruling?
No, Your Honor. Thank you.
All right. Counsel, we do have some other hearings we need to get scheduled, including, I guess, hearing on a motion to compel, change venue, and motions to dismiss. My preference, given the time, and I'd like to just arrange a conference call with counsel to look at calendaring and get these matters set. So I'll be available in the coming week. I'll reach out to counsel and let's look at our calendars and see when we want to get these additional motions scheduled. All right. Anything else we need to bring up on the case this afternoon then?
No, you're good.
Not-
Thank you.
No, Your Honor.
All right, thanks everyone, and thank you to the Idaho Supreme Court for their support, as well as Fremont County. We'll be in recess.
Well, there you have it, Crime Talk aficionados. Fortunately, I don't have to come here and eat some humble pie. As the court agreed with my analysis, that nothing rose to the level which would result in any kind of sanction that would require Mr. Wood to get off the case whatsoever. I'm surprised the court had to take such a lengthy recess to issue that order, because you would have thought that he would have had that prepared already. Basically, his analysis was that of mine, that the defense who brought this motion, who had the burden for this motion, had to present some evidence that was somehow going to show that the conduct somehow tainted the fairness of the trial or that of the witness in any particular way, and basically adopted the arguments of the prosecution in his ruling. I thought it was a little funny in regards to the referring to Mr. Means as not as a competent attorney. He basically said that as professional attorneys, we should all have civility, and he expects ongoing civility among professionals, and basically you shouldn't disparage them. And I totally agree with that, but it's not like he's going to have Mr. Wood apologize to Mr. Means. But he did say basically, hey, if you can't be civil, guess what? Bring it to my attention, and we'll take care of it. It was interesting that the Bar Association, Idaho Bar Attorney Regulation, was involved because the judge referenced them, and there may already be a companion case whatsoever with the attorney regulation as regards to Wood. I would not surprise me if that's what took place, given the way these proceedings went forward, but I think that they would reach the same conclusion whatsoever. At most, maybe a public censure, but I don't think that there's, and like I said, I'm a defense attorney, and if I thought the prosecution was doing something wrong, I would jump all over it, and I just didn't see it here. And once again, you have a situation where the defense, predominantly Mr. Means, remember he brought the whole, my client needs a bond because they're listening to telephone calls at the jail. Well, turns out that wasn't the case. They put up the sheriff and they said, hey, maybe we record one, but we deleted it as soon as we realized it was an attorney call. Waste of a day, waste of client's money. Here, who knows how many hundreds of hours went into preparing for this. And you really had to ask yourself, what was it going to accomplish? I didn't see it. Now all you got is a prosecutor who is not going to trust you, is not going to give you any benefit of the doubt and say, hey, that prior guy, that Means guy, I don't understand, they're just doing their job, good guys. At the end of the day, at the end of this case, we'll all shake hands and go have a beer or something. Don't see that coming forward. I've generally looked at it in life as you think I've done something wrong, fine, you keep me in the courts. But as soon as you grieve me, you start saying unethical things about me, game on, because at that point you're messing with my livelihood. And here in this particular situation, Means and Pryor were messing with Mr. Wood's livelihood, his ability to practice law, by basically making allegations that he had engaged in criminal conduct where his law license could be suspended. I wouldn't just brush that off. I would remember that for a long, long time. That would be little hard to get by, to say the least. And at the end of the day, what did they accomplish? They pissed off a DA, made them look like they were, for lack of better terms, I don't know. I just don't get it. One of the things you learn as being a defense attorney is if it's a trial case, you save what you have for trial. You know, clients always want to file motions. File this motion, blah, 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 file the motion. Okay, but I'm telling you, it's probably going to be denied. The case law is not in our favor, and the judge is going to follow the law. And that's where it's going to come out. And I hate to have to tell the client that that's probably what's going to happen. We'll file the motions, but don't expect to win it. If you're going to win it, you're going to win it at trial. I have literally lost every motion. I have a judge, I swear to God, I don't think he's ever granted a motion in my favor, but I've gone to trial and won like 3 cases back to back to back in his courtroom. And it wasn't for the prosecutor or his effort not to do that. So, you know, to make sure that wasn't going to happen. But that's just a part of life. You don't always get to run to the teacher and say, somebody's picking on me. They're being mean to me. You know, we wanted to know about this 18 minutes, and what if it wasn't recorded? Okay, well, it was. And what's wrong? So I just do not see it. I told you that when the whole issue broke out. People were sending me things saying all these people from Court TV were saying this was serious, it was egregious. Okay, and I don't watch Court TV, all that other stuff. But I wonder, when was the last time these people practiced law? When did the last time they ever have to deal with prosecutors on a daily basis? You don't go putting fingers in people's eye and poking them in the eye and then expect them to be nice to you. Don't get me wrong. There's a chance, there's an opportunity where you have to be mean, and sometimes you have to poke some people in the eye, figuratively speaking, obviously. But you don't do it unless and until either A, they bring it on, or you've tried everything else. You've tried being nice. You've tried to be completely hospitable, and they just keep treating you like crap. And I've had situations where I've told DAs, like, is there something I've done to you? Because I don't think we've ever met, and you just treated me real rude. And I had a young DA once, tell me, well, I just don't like your client. Like, okay, but doesn't mean you have to be disrespectful to me. In fact, I may not like your boss, but let's do this job. You're doing your job. I'm going to do mine. We're going to both do it to the best of our abilities, legally and ethically. So there you go. We'll see. There may be some dueling grievances going on in this particular case. If if Means and Pryor grieves Mr. Wood, guess what? There may be a counter grievance going on. And like I said, you're not supposed to go around making those accusations unless you can absolutely back it up. You just don't do it. So anyway, I think that's all we've got for today. It's been a long day. Thanks for everyone sticking it out. I think what we're going to try to do is cut out kind of my commentary and put it up again, so hopefully everybody can see it. Maybe we'll put the judge's ruling in there, so you don't have to watch the whole. How many hours was it? 2+ hours or something? 4 hours with a little bit of waiting. We'll put hopefully the interesting part, me and the ruling, into a condensed video and put that up. So relieved. I was getting worried that maybe I was going to have to eat that humble pie. That's okay. I could do that, but I didn't think I was going to be wrong. We try to get it right. We try to get it right for you because why? We want Crime Talk to be the place where people go when they want and need good advice based upon the information we have. So thank you all for watching. Thanks for watching Crime Talk. We'll try to get that video up for everybody to watch again. Thanks for sticking it out. Absolutely appreciate it. Have a wonderful day, and we'll see you next time on Crime Talk.